There we go. Good morning. This is the final argued case on the January 13th docket of the Kansas Court of Appeals. My name is Gordon Atchison. I'm the presiding judge. Let me go ahead and introduce my colleagues. I'm pleased to be sitting with Judge Stephen Hill of the Court of Appeals, who is, I believe, the longest serving law trained judge in the state of Kansas these days. I'm also pleased to be sitting with my Court of Appeals colleague, Judge Gardner, who is a longtime member of this court, not nearly as long as Judge Hill has been a judge. And I've been on the Court of Appeals for just over 11 years now. So you have your sort of standard issue Court of Appeals panel. Nobody, no senior judges, no special designees, well, just us. The case we have in front of us is David and Leslie Snodgrass versus the city of Wichita. It has been set for our standard 15 minutes of argument per side. I will remind the lawyers that we have read the briefs and we're familiar with the arguments and in general the factual background of the case, not to tell you how you want to argue, but we kind of know where you're coming from and you can just jump right into the argument. Mr. Parker, as the representative of the appellants, you may reserve a portion of your 15 minutes for rebuttal, but I need to know how much time you would like for rebuttal, if you would like rebuttal.
Yes, Your Honors. May it please the court, I respectfully request to reserve 8 minutes of my 15-minute time allocation to respond to the argument.
That's your, well, you know, actually, I think somewhere along the line there's something that you can't reserve more than half your time.
Then just half is fine, Your Honors. I have a very brief argument.
Well, okay, we may have some questions. Keep it going for a little bit, but yep. All right. I will put it down to 7 minutes of rebuttal time, and please proceed.
Thank you. Thank you, Your Honors. I have timed my argument, and it lasts less than 4 minutes. So I beg the court's indulgence for a brief introduction, then I'd stand for any questions.
We punish nobody for brevity. Counsel.
Thank you, Your Honor. The court's faced with an unenviable task, whether to believe the arguments of a David-like plaintiff's attorney about a seemingly irrelevant legal question, the taking of excess special assessments, or whether to uphold the actions of the Goliath in our case, the largest independent local government in our state, the city of Wichita. My job's not to convince this court of the correctness of my position. That's for the courts to decide. My job's simply to place the right questions before the court to answer in light of the case's factual background. Here's a very brief summary. The city refinanced bond financing for public improvements serving many private developments over the past decade. Kansas law mandates that property owners benefiting from such improvements pay these assessments in direct proportion to the benefit they receive from the improvements. There's no dispute between the parties that there's a known percentage of savings gained from the city's bond refinancing. The city argues it can keep the more than $5 million of savings, and appellants argue it cannot. Since the 1890s, the U.S. Supreme Court in Norwood versus Baker has ruled that excess special assessments are takings. The city claims that because the U.S. Supreme Court allowed governments not to be perfect in allowing a special assessment cost, allocating them rather, the city can use this grace to pocket known excess assessments gained from bond refinancing. Appellants think this is wrong and that these savings should be returned to the taxpayers. The city has never produced a case from anywhere in America stating a city is allowed to refinance these bonds and pocket the savings. That's because there's no such case. Additionally, appellants have identified multiple Kansas statutes criminalizing city use of excess special assessments to pay for anything other than the costs of the projects for which they were levied. Yet the city claims it can pocket these savings and use them to fund other projects paid for out of its bond and interest fund. Again, the city provides no case from Kansas or anywhere else in America allowing for this to occur. Finally, the trial court ruled against appellants, not by citing any law in favor of the city, but by ruling that appellants consented to the taking of excess special assessments by continuing to pay the originally levied assessments. There's no case anywhere in America stating a taxpayer can consent to a taking. Also,
Counsel, may I interrupt you for just a second?
Absolutely. Yes, Your Honor.
In hearing your argument, it makes me think I've got visions of large piles of cash being delivered to the city government of Wichita as a result of this refinancing. But in actuality, aren't they just saying we're having less debt than we used to?
Yeah, let me paint a picture. I'll give you an idea of what it really boils down to, Judge Hill. All right, so there's maybe 25,000 affected taxpayers, right? They may be paying $200 to $300 a year each. The city came through, just like if you were to refinance a house, they dropped the interest rate from 3.5% to 1.5% when the market went down. The only difference is when we refinance our house, we get to put the savings back in our pocket. City kept the savings. Under state statute, there's no provision for that. They can refinance, but they can't keep known excess special assessments. That's the argument.
Well, their savings comes in the future payments that don't have to be made, correct? It's not like they get a big cash.
Judge, actually, they do. They're not lowering any of the future assessments. That's the problem. What they should have done is they said, look, we refinanced. Now the future payments, they should lower them. That's not what they did. What they did was they said, okay, wait a minute. We refinanced the bonds. We dropped our interest rate, but you keep paying at the original payment price and we'll hold the money. And then we'll use it for something else. All they had to do to make this right was do exactly what you just described, Judge Hill. All they had to do was, okay, great. We refinanced, just like if we refinanced your house, your payments drop. All they needed to do was re-levy the assessments, lower the payments, no taking. They didn't do that. So
is your client's stated injury here approximately $300, or is there some dispute as to the calculation?
It's approximately $300. There's no dispute in the terms of the percentage savings. All right, it's approximately $300, $300 to $400. I don't have the exact math in front of me, Judge. It's not. The problem is that it's not about the $300 for one person, right? It's the same reason why people that commit money laundering can get away with it, because that commit financial fraud, like accountants that skim off the top, right? It's in the fraction of the cents. All they did was they lowered it 1.5% or 2%, right? It's only $300 to each person, but they did it to 25,000 people. That's how it racks up to $5 or $6 million. And all we're saying is, wait a minute, you guys know exactly how much you saved on each person, right? Because everybody saved, they all paid an additional 1.5%. Just send the 1.5% back. They're not willing to do that. That's the only reason we're here.
Do you have any legal authority that would apply the Norwood, the substantial excess standard that you have to meet in those types of facts?
Yes, ma'am.
Where you have minimal injury to individual plaintiffs?
All right. Yeah, I want to go back to that. All right. The language in Norwood says, okay. Nope. The language in Norwood says, in substantial excess of the special benefits accruing to him is to the extent of such excess a taking. We say substantial excess because exact equality of taxation is not always attainable. And for that reason, the excess of cost over special benefits, unless it be of a material character, ought not to be regarded by a court of equity, okay, when its aids revoked to restrain the government. Here's the problem. This isn't about the original levy of assessments, okay? When they originally levied, they apportioned all this out. We're not saying that they didn't do that right. They did that. They said, look, we didn't none of the people challenged the original assessments. Everybody was paying their direct proportion, okay? What happened was there's now a known excess. They know that everybody is paying 1.5% more than what is necessary, right? So in Norwood, where there's a known excess, even if it's 1.5%, you can't keep that, right? What Norwood's saying is, look, if I got one person next to me and they have to pay a little bit more than my other person over here because we didn't quite do the math right under state statute when we're levying it, you can't invalidate all the special assessments for that. But there's no case in America that says that you can refinance and pocket the savings. And to my knowledge, no one in mass has ever done this before, anywhere in the United States. No one has refunded. And quite frankly, the bond market wasn't set up for this. We've never had this much of a savings since the 90s, when things went down so dramatically then to allow this to happen. No one's ever refunded this much special assessment money and then pocketed the savings. So I don't have a case that says, hey, you can't do this because no one's ever done this before. It's patently not allowed under the U.S. Constitution.
Mr. Parker,
yes, ma'am.
Could you please address the statute of limitations question? And if you believe the 30-day statute applies, or if you believe it's an implied contract, why are you not out of time?
I'm not out of time because primarily, if you have here's what happened, okay? Each year, the city came through the way that they did this refunding, all right? If you look at the newspaper clippings from back in petition, you can see it. They don't even list the projects directly. They reference the prior ordinances that referenced which projects were being specially assessed. They never called the property owners and said, hey, we're going to refund and lower you 1.5%. They never did any of that. Then they never sent an official notice out to anybody. They never even held a public hearing and said, hey, we're doing this en masse across the city of Wichita. Everybody you need to know, we're lowering it 1.5%. That's what we're doing. That's our program. No. They just said, hey, we're refunding some bonds. It's all included in these series. It's going to be great. We're going to save 50, 60 million bucks overall, right? They just kind of put that out there. They never told anybody. And then they allowed Sedgwick County each year. Sedgwick County sends the taxpayers a bill that says, here are your special assessments. If you don't pay them, your property is going to get foreclosed at tax foreclosure. So every year they sent out a new bill to the taxpayers. They allowed Sedgwick County to do that said, here's your current special assessment levy. Here's what's left to pay. And they kept forcing that every year. So there's no way that the taxpayer could come up with adequate notice of what had occurred. So even if you're going under the implied contract that you gotta have 3 years or whatever, my clients couldn't even adequately identify that this had happened after I talked with them about it. It took me days to find out, to confirm that this actually happened as counsel for plaintiffs. Took several days.
Mr. Parker, what statute of limitations does apply? Or are you just saying there is none in this case?
I believe that if you look at the implied contract claims, I think that if you've got fraud, it tolls that. I have looked all over the United States. There is no statute of limitations for a takings claim. That's the primary claim here. If you look at it, the Fifth Amendment to the U.S. Constitution says, nor shall private property be taken for public use without just compensation. It doesn't say, hey, wait a minute, you can take private property for public use without just compensation if you do it and they don't challenge it within 5 years. There's no statute of limitations that says the Fifth Amendment doesn't apply. If you take, you pay.
Thank
I have
you.
a couple of questions.
Yes, sure.
Is the city under any duty to issue refund bonds if the interest rate drops?
No.
Do they have to do it? Okay.
No.
So it's, and your argument is if a city does do it, the savings and interest has to be refunded to the people who are paying the special assessment.
Yes, Your Honor.
Okay, why would the city ever do that then? Why would they ever issue refund bonds?
That's why it's not happened like this in mass in the past. Now, I'm not trying to say anything. I've had a lot of learned counsel on the other side. I'm not throwing stones in a glass house, but I can tell you that people made 3%. They have a city bond advisor and a municipal fund advisor that each made 1.5% or 2% or 5%. I don't know what the exact figures are. They made it off of advising the city to issue the refunding bonds. There was
I
no
understand.
reason.
And the Kansas legislature has provided a statute as a vehicle to do that.
Right.
But I'm wondering, okay, but why would any municipality ever do it if there's no benefit to the municipality?
Well, there's only maybe 2 reasons why you would do it. The
I
statute.
probably should ask Mr. McLeod what, but go ahead.
Yeah,
why would?
So the only reason why you would do this, you don't need to do it. There's no, if you have a bonded debt limitation, okay, and underneath Kansas statutes, all these special assessment bonds, they're usually general obligation bonds, right? And so there's a limitation of debt that you can issue out, right, as a general obligation. You can issue a thing called a special obligation special assessment bond, which takes it away from your general obligation debt lid if you're a municipality. So you could issue refunding bonds to lower your debt lid, right? But again, nobody does this. This has never happened before in the past.
Are you saying that the city of Wichita has never issued refund bonds other than this one occasion?
Oh, no, they've done that. Other cities have issued refund bonds. Refund bonds are fairly common, just not with special assessments to lower interest rates and pocket difference. That's just what's uncommon. Yeah.
I'm going to ask Mr. McLeod this question also. I mean, it shows my ignorance about this whole process of bond stuff. My understanding from reading the briefs and trying to puzzle through the statutes is that the special assessments go into a city account or a debt fund and then are used to pay off the bonds. And it's my understanding, correct me if I'm wrong, that the particular series of bonds for this refunding, once they're paid off, if there's money left over that was generated from the assessments for those bonds, that goes into the city general fund, or does it still sit in this debt fund in perpetuity?
I think it sits in the debt fund in perpetuity. That's what they've said, that they've never transferred it out. The way that they can get done with it is it basically sets in there for an extended period of time. And then if they ever stop issuing debt, which the city of Wichita will never stop issuing debt, they're too large, then they could transfer it out into the general fund.
Well, that's what I was asking. I mean, is it the indebtedness of these particular bonds, or is it all city indebtedness and they can transfer it out?
It's these particular bonds go into the bond and interest fund. Most of the city bonds go into bond interest fund, right? A lot of city bond, like if you're refinancing a special assessment bond, you can take those savings and use them for other things. Okay. It's not as specifically dedicated. Here's what makes this unique, right? It's like you're financing a little slice of the thing that serves a residential development. They don't even do this in other states, right? Usually you buy a lot for $50,000 in another state. They don't do this in a lot of other states. They do it in some. Usually you buy your lot for $50,000 and the developer pays for the sewer and the water and the streets to go in. In Kansas, we sell a lot, particularly down in Wichita, for $15,000, and the city finances $25,000 for the developer of the water lines, the sewer lines, and the street lines. What the city said is, okay, we're going to take the savings off the $25,000 that services your particular development, and now we can use it to pay for projects that service other parts of the city for which you are not peculiarly benefited. That's the problem, right? Under the laws of the state of Kansas and the U.S. Constitution as interpreted by the U.S. Supreme Court, you can only have special assessments that are levied and then utilized to pay for the stuff that is peculiarly benefiting these people. They can't pay for the street project and take money that's used to pay for the street project in front of your house and pay for Rock Road down the street. That's the problem. They need to take the money that's not used for the street project in front of your house and give it back to you. They can't pocket that and use it to pay other projects. That's what's going on.
Okay. You've used up your 7 minutes and then some.
Thank you, Your Honor.
We'll give you some rebuttal time, and if Mr. McLeod wants a little more than his 15 minutes, he's got that. But let me turn it over to you, Mr. McLeod, and explain to us why the city has complied with the Fifth Amendment, Kansas law, and is otherwise properly entitled to summary judgment in this case.
Thank you, Your Honor. Can you hear me?
We can.
Okay. First, I want to say that although we should be sticking to the record, all of council's statements about how common this practice is, none of that supported in the record. And if I can just indulge in the same, to my knowledge, the city's practice is an extremely common practice. There's maybe one jurisdiction in the entire state that I'm aware of that would attempt to refund savings. And I think that's Sedgwick County. So it's common. The city of Wichita has always done it. And the city of Wichita has always done it very publicly. It's been discussed in public meetings of the city, whether it's a good practice or not, and it's a very long-standing practice. So all of that generalized stuff that council said is not correct.
Let me ask, I'm sorry, before you get on to the other stuff, let me ask you the question I said I was going to ask you that I asked Mr. Parker. And I'll rephrase it slightly. Under what circumstances can the city of Wichita take money out of this debt fund that has been paid in on the refund bonds that are at issue here?
Okay.
Or does it sit in this debt fund forever?
No, let me explain what we think the reading of the relevant statutes is on that. First, the city does not pocket it. We do not put the savings in the general fund and use them for general city purposes. We rely on KSA 10-118A to move the revenue stream that supported the refunded bonds over to the refunding bonds. Once the refunding bonds and the interest on the refunding bonds have been completely paid, we believe that KSA 10-117 prevents the city still from taking that money out of the debt fund for any purpose other than to pay debt service, bond principal, and interest on other general obligation debt. So we leave it in the bond debt service fund and we use it for that purpose. And the appellant's contention that it can't be expended for any purpose just doesn't make any sense. Their contention that we just have to leave that money in debt service fund forever.
Counsel, let me ask you a question on what you just said. So if I understand what you're telling us correctly, money that you're getting in on this debt service, once that's done, then you will apply that the same revenue stream to other projects.
We'll apply it to other outstanding bond issues.
Right, because you're now in the bond and interest fund.
Right.
And so whatever those projects are, that revenue stream will be applied to that.
Yes.
Do you have a constitutional problem with that? Because
No.
it's levied for one purpose and going to it for another purpose?
No, Your Honor, since 1908, the Kansas courts have recognized the concept of surplus revenue with special purpose taxes. There's a case cited in our brief that says that once the purpose of the special purpose taxes has been accomplished, if there's a surplus, that surplus can then be used for other purposes. And we believe that the intent of KSA 10-117 is to use that money for other general fund purposes. And there's yet another statute that we haven't discussed yet, KSA 10-117A. And that statute basically says that only at such time as the city has no remaining outstanding general fund debt can the city take any can the city take any surplus from debt service fund and use it for general purposes. So that string of statutes, KSA 10-118A, KSA 10-117, and KSA 10-117A signify to us that when the refunding bonds and the refunding have been paid off, surplus from that revenue stream cannot leave the debt service fund except for other debt service payments until such day as the city has no general debt outstanding. And Your Honor, I mean, the way the city issues bonds periodically, that will never happen. So the choices here are the city can use that money for other debt service, as we believe, consistent with the 1908 Kansas case cited in our brief, and the statutes that I've referenced, or that money has to sit as an unexpendable balance in debt service fund forever. And there's just no sense to that, Your Honor. There is no reason that the legislature would have intended that. Now, to turn to the appellant's attempted use of those same statutes to say, well, then the money has to be paid back to them, their own argument proves that that can't happen. Under the statutes that they cite for that argument, 10-118A and 10-117, to take money out of the debt service fund and pay it to property owners, that would be the kind of criminal action that they allege misappropriation of funds to constitute. So even if their argument could manage to stick this unexpendable balance in the debt service fund forever, they're missing the bridge that gets that money back to them. There's no statute that says that can be paid back to property owners.
Well, what about the constitutional argument that amounts to a taking if it's diverted to other debt? Why is that wrong?
Your Honor, there is a basic mistake, an analytical mistake that appellants are making throughout their argument. And the essence of that mistake is there is a difference between the costs of the project that are allocated, and that's the issue that the Norwood case is about, allocation of project costs. So we're talking about the hard costs of construction, administration of the project, and construction period interest that gets capitalized to the project. Those are the things that are going to be spread under KSA 126A08 under whatever the formula is in the petition. And when you have a 100% petition by all of the owners that are asking for the assessments to be made, that spread can actually be made any way those owners ask, because it's a giving. When you're dealing with a voluntary assessment with 100% of the owners joining in, it's a giving, it's not a taking. And subsequent owners who come along, in the posture of the appellants here, they're essentially buying the deal that Mr. Peak, their predecessor entitled, made, which was that the city's going to do the project costs are going to be allocated. And then when the project costs have been allocated, the interest we're talking about is actually an add-on that is done under KSA 126A10. It's not part of the allocation of the project cost. And that's where the appellants persistently confuse things. It's not the issue that Norwood's dealing with at all. It's not the allocation of the project costs. It's the setting of the separate interest rate component that happens after the costs have been allocated to the different lots. So we do that under KSA 126A10. And what 126A10 says is, let me back up on the principle for installments under 126A10. Those have to be spread equally. So they have to be the same for every year, which is a difference from prior law. And I want to say a little bit more about that later. And then the city, the governing body, is allowed to set only one interest rate for all those installments. And that interest rate has to be at or under the cap that's set by KSA 10-1009. So our position is when the governing body does that, the initial certification of that interest rate, if that rate is compliant, if it's under the cap of 10-1009, and the city clerk certifies that amortization schedule over to the county, and they do that at the time the assessments are first certified, there's no provision in KSA 126A10 to ever come back and revisit that rate. And now to explain a little bit about why I think that is, let me compare 126A10 with the method that existed under KSA 10-114 in the years before the 126A statutes were available. Back in the revisions of the General Bond Law in 1923, KSA 10-114 was first created. It was relatively a very simple time in the municipal markets, in the financial markets in general. The stock market collapse of 1929 had not occurred. The Great Depression had not occurred. The New Deal had not occurred. Nobody had ever heard of the Glass-Steagall Act, the Securities Act of 33, the Securities Exchange Act of 34, the Trust Indenture Act of 1939, or the Investment Advisors Act of 1940, or the Internal Revenue Code of 1954. And when a city was ready to spread its assessments in that day, the city clerk just got out the bond amortization table. And the method is very elegant in its simplicity. You take your principal installment for the current year, whatever that is, the interest that's going to be due on that principal installment in the current year, then taking the various principal amounts and the various interest rates for the future maturities, you compute an interest only number for those future maturities, and you add that all together, your current year principal and interest payment and your interest only for the future maturities, that's your gross assessment, and you just split it out according to the formula that's in your assessment ordinance. Now, if you flip to the next statute over, KSA 10-115, you can see something that strongly contradicts plaintiff's argument that certifications had to be revised later on if there's a reduction in the city's borrowing cost. And let me point out that also wasn't true under KSA 10-114. The city could either certify year by year, or the certification could be made all at once for all the years, but you would use the same formula either way. 10-115 says that if a property owner wants to come in and clear the assessment before the bonds are issued, they come in and they pay only the principal amount that would be spread to their property, and it's done. But if they come in after the bonds are issued, if, for example, a property owner comes in year 2 of a 20-year assessment and says, I want to clear these assessments from my property, they have to pay not only the principal amount that's spread to their property for all of the years that would have been scheduled, but they have to pay the interest on it as well. For every year the interest was scheduled up to the final maturity. And even though the effect of that, Your Honors, is that the city's borrowing cost as to that parcel has now been at least substantially reduced or eliminated potentially, the property owner gets no discount for that. They have to pay the full undiscounted amount. And so there's just a clear indication right there that the legislature doesn't require subsequent revision of certified specials to make an adjustment when the city's borrowing cost is reduced. Now, when we fast forward to 1957 and the passage of the 12.6a statutes, in the very first iteration in KSA 12.6a10, the legislature adopted this smoothing method. So instead of the mirror image matching your principal and interest rates exactly like cities did under KSA 10-114, now the installment for every year of the assessment period has to be the same, and the city has to pick only one interest rate for all of them. The effect of that is that in some years, the city is going to be collecting a special assessment installment that is larger than the bond principal due that year. And in other years, the city's going to be collecting a special assessment installment that's smaller than the bond principal that's due that year. And the city is going to be gaining or losing in the course of that over the 15 or 20 year, whatever the assessment period and bond period is, according to the time value of money and the fluctuation of interest rates in that period. And the city can't know at the time that it's issuing the bonds and certifying the rate, the city can't know what those fluctuations will be, or whether the end result is going to be a wash or a net interest cost to the city or a net interest savings to the city from that back and forth, with some of the principal installments being less and some more than the special assessment revenues coming in to pay them.
Mr. McLeod, let me ask you to switch gears a little bit. If you would please address the statute of limitations issue, because Mr. Parker has said that really there is no statute of limitations for a taking case. And it looks like the cases, I think, that I've looked at that enforce the 30-day statute of limitations, which you're arguing applies here to bond assessments, don't deal with the takings issue.
Well, I mean, Your Honor, we obviously don't think that it is a takings case. And I don't really recall whether anybody phrased their complaints in prior 6 12(6)(a)(11) cases as takings or not, but they always involve people thinking that they were paying unfair shares, and they could have been equally characterized as a taking if people had wanted to try to make that same argument. The root of our raising 12(6)(a)(11) is that in the appellant's pleading, right, they say that the effect of the 2011 refunding was to invalidate the assessment. So now on appeal, they're saying, well, that's not our argument. We've got this different argument, but they've never amended the pleading. The pleading still says that the 2011 refundings made the assessments invalid, and the application of KSA 12(6)(a)(11) to that is just clear. You can't attack the validity of assessments outside that 30-day window, and that's an absolute. So that's the reason that we raised that statute. In the course of the district court's evaluation of the evidence of record and entry of her findings, she also noted that the tolling argument was unsupported, raised by the appellants. And to the extent that that's the case, then all of the other statute of limitations, which I think we've identified in our brief what those periods are for the civil rights taking claim, for the implied contract claim. If the statute was not told, I think they're out of time on everything, given that the rate that they're complaining about was certified in 2004 and has never changed since that date. And the refunding they're complaining about occurred in 2011. And this case was filed, I think, in 2018 or thereabouts. So very long time passed. And again, Your Honor, I think if you look at 12(6)(a)(01), there's really no provision in that group of statutes, or really in any statute, to challenge the KSA 12-6A10 interest rate at all, ever, if that rate was set in accordance with the rate cap when it was set. And the reason that I think the legislature gave the cities a safety margin in that rate cap is the issue that I've described with the computational issues that come up and the market risks that come up when the city has to do equal annual installments and choose only one interest rate. I think it's because of that the legislature gives the city a rate cap in 12(6)(a)(10) that is not tied to any of the interest rates on the actual bond maturities. It can be whatever rate is allowed by KSA 10-1009 at the time. When the legislature first adopted the law in 1957, instead of 10-1009 didn't exist at the time. So instead of that, the initial law that the legislature passed said, well, city, you've got to do the equal annual installments. You've got to choose one interest rate, but it can be as high as 6%. That was the first iteration. Later, they came back in laws of 1970. I think it was chapter 64 and section 100 and 104 of that chapter set up caps saying, well, now you can do under this law 7% on anything that's a general obligation debt and 8% on anything else that the rate is set under this statute or an act that is mandatory of. Coming forward, it's been amended more times. And as
Mr. McLeod, you've gotten beyond even your extended argument time at this point. You want to take a minute or so and sum up, if you would. I don't mean to cut. Do any members of the panel have additional questions for Mr. McLeod? Why don't you take a minute to sum up, and then we'll hear from Mr. Parker.
Sure, Your Honor. I hope that the relative merits of the parties' positions are ascertainable from the briefs. I think that the dismissal of the claims against the city were properly rejected by the district court because the Kansas statutes and case law cited by appellants don't establish a duty to reduce the interest rate on assessments following a refunding. They haven't established a taking. And I think the court correctly found that the claims are barred by the applicable statutes of limitation. And further, the judgment below is additionally supported by the Kansas Tort Claims Act immunity provided in 756104F and the failure to comply with KSA 12105BD. As to those issues, the appellants briefed only a single argument, and the argument that they made was we get out of those statutes because we called this an implied contract, but the cases cited in the city's brief show that you don't just accept the label, you look at the actual nature of the claims, and where the claims allege the breach of a duty imposed by law, they sound in tort, and the governmental immunity of 756104F is applicable, as was KSA 12-105BD, and both the immunity and the failure to comply with the pre-suit notice statute are additional reasons barring the claims.
Thank you. Mr. Parker, we had kind of well exceeded what you had reserved for rebuttal, but why don't you take about 4 or 5 minutes there, and if we have some additional questions, we'll ask, and you can sum up your client's position for us.
I can stop for questions now if anybody has anything. Okay, let me, I'll be very brief then. Takings aren't torts. There's Kansas Tort Claims Act. If you want to get rid of all the other claims, the implied contract claims, it doesn't really matter. It's still a taking. Taking is a separate cause under the U.S. Constitution. There's no statute of limitations for it. We're a notice pleading state. Legal arguments that supplement the claims that are laid within a pleading are always allowable. Additional arguments have been made throughout the case. Returning to funds to taxpayers isn't criminal. There is allowance for the relevy of special assessments where savings have been identified by a city. It's in state statute in the 12(6)(a)s. The 1908 case that was referenced has to do with a county-wide levy to every resident within Butler County for the construction of the historic jail courthouse. I still get to practice down there every once in a while. It's really neat. It's well done. But that was from 1908. It had absolutely nothing to do with special assessments. It wasn't a special assessment. It was a uniform assessment for a specific task that was countywide. And they said that if there's an excess after the thing's built, then you move it over to the general fund. There's no case that says that you move money out in another way. There's known savings. These aren't adjustable rate mortgages. Their bonds are financed at a fixed percentage. There's no way that that things change between the time of refunding to the end of it. That's going to eat up the 1.5%. Otherwise, they wouldn't have refunded. So finally, I'll just leave with this thought. 3 questions. If the city is right, why can't it identify a case anywhere in America affirming that a government can pocket known savings from a special assessment bond refinancing? Second, if the city should be able to pocket these savings, why are there Kansas statutes criminalizing the use of special assessment funds to pay for anything else other than the projects for which they were levied? Finally, and most importantly, does it feel equitable and right to this court that the city gets to pocket more than $5 million of known excess special assessment savings and use them for projects other than those for which they were levied, because that's what the city just said they're going to do? Or should the city be compelled to return them to the affected taxpayers? This is the end of my formal remarks, and I leave this court with 2 parting thoughts. As the son of 2 Kansas attorneys, I was taught from a young age that the simplest argument is usually the correct one. In addition, I have often heard it said that the purpose of the law can be summed up in the following statement: where there is a wrong, there is a remedy. I only advocate that this court apply the law to do what it thinks is right and just in this circumstances. Thank you so much for your time and your consideration.
Thank you both, counsel, for your arguments in what is something other than a run-of-the-mill case for us. And it's nice to see those every now and then. We will take the matter under advisement and get out an opinion as soon as we can. That concludes both this argument and our argued calendar. So we stand in recess. Thank you.